All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Could the court officer please call the case?
Good morning, Mr. President, Your Honors. Situation in the Central African Republic 2, in the case of the prosecutor versus Alfred Yekatom and Patrice Edouard Ngaïssona. Case reference ICC 0114-0118, and for the record, we are in open session.
Thank you. I ask for the appearances of the parties. We start with Mr. van der Poeyen.
Good morning, Mr. President, Your Honors. Good morning, everyone. Today, the prosecution is represented by Olivia Strouven, seated behind me, and behind her, Eric Iverson. I'm Kwaku Venpoy. Good morning.
Thank you. And the legal representatives of the victims, perhaps Mr. Suprun first.
Good morning, Mr. President. Good morning, Your Honors. The former child soldiers are represented by myself, Dmitry Suprun, counsel at the Office of Public Counsel for Victims. Thank you.
Thank you. And Ms. Masida.
Good morning, Mr. President, Your Honors. Les victimes des autres crimes.
The victims of the other crimes are represented by myself. Ms. Rabesandratana has not been able to be here on time this morning. She sends her apologies. She will join me later. I'm also assisted by my colleague, Mr. Yarifal.
Bonjour, Monsieur le Président. Bonjour.
Mr. Fall. Good morning, Your Honors. I am indeed present. I am speaking to you from Dakar in Senegal. Masida. And in Bangui, my colleagues Marie-Edith Douzima and Abdou Dangabo Moussa are present. Ms. Douzima. Good morning, Your Honors.
Dangabo.
Good morning.
Mr. Moussa. Good morning. I'm Mr. Dangabo.
Now we turn to the defense. We start with the defense of Mr. Yekatom, Mr. Dimitri.
Good morning, Mr. President. Good morning, Your Honor. Good morning, everyone. This morning, Mr. Yekatom is represented by Thomas Hannes, Associate Counsel. We have our legal intern, Camille Gillin. In the public gallery, we have our legal assistant, Guillaume Suzuki, and our case managers, Wilhelmina Whittingham and Sabrine Bessa, and myself, Mylène Dimitri, lead counsel.
Thank you very much. And for the defense for Mr. Ngaïssona, welcome, Mr. Knops.
Good morning, Mr. President, Your Honors. The defense of Mr. Ngaïssona is represented today by my associate counsel, Mr. Omisi Namkime, and case manager, Chiara Giudici. Thank you.
And Mr. Knops, I can already give you the floor. It's your turn for the presentation of the opening for your client.
First of all, Mr. President, Your Honors, I'm grateful to the Chamber for the understanding of the situation last Tuesday in my private life. Thank you very much. And I'll extend my gratitude on behalf of my family to the Chamber for the understanding, and also the parties and the participants for their support and understanding. Thank you very much. Mr. President, we have presented a roadmap of our submissions for today. You find on the screen. The first part will deal with the defense case as to the history of Mr. Ngaïssona and his person. And the second part of the roadmap consists of our defense case in regard to the conflict itself. And the role of Mr. Ngaïssona will be delved into the third part of our defense case. We forecast what we intend to establish in our defense case, and the conclusions at the end of our submission will be delivered by the Associate Counsel, Maître Omisi Namkime. Mr. President, Your Honors, last Tuesday, the prosecution, in its opening statement on page 27 of the real transcripts, stated that justice is necessary for Peace and Reconstruction of the Central African Republic. We agree with the prosecution that the population of the Central African Republic deserves justice. However, we submit that justice should and must be based on the reality and the truth, what happened in the Central African Republic within the time frame relevant to the crimes charged. And this is also applicable as we submit to the person of Mr. Ngaïssona, who he was and what was his exact role within that time frame. And this you will hear from the defense. Today, we will foreshadow our case in this regard. Mr. President, Your Honors, this case is about a human being, a person, Mr. Patrice Ngaïssona, whose endeavor in life was to bring peace and unity in his country, to reunite his people. A person who was refusing to use violence, was refusing to use military means to achieve this goal. This is our defense case. His weapon, if we can speak about weapons in a metaphorical sense, was to making his experience with sports, football, instrumental also for the unification of his people from all ethnicities. How? It will be our defense case that you will receive an answer to this important question. To foreshadow our case, we say to the Chamber today that on the 25th March 2008, Mr. Patrice Ngaïssona was elected President of the Football Federation of Central Africa in the presence of the Special Envoy of FIFA, Mr. Jacques Anouma, member of the FIFA Executive Committee and President of the Federation Ivoirienne de Football. A position which Mr. Ngaïssona assumed to continue to occupy during the time frame of the charges. And the relevance of this observation, Mr. President, will be shown later during our presentation. It is quite telling, Your Honors, for the life story of Mr. Patrice Ngaïssona and his personality, and also for the
Perhaps may I say the following? It's of course unfortunate that you are interrupted like this, Mr. Knops. This can happen. But let me say the following. We have representatives for the victims in the courtroom. So if there is any problem with the connection in Bangui, we simply continue. You know, this would, because we don't have it under control, and it would perhaps be nice if we could avoid that we have the loud music when there is connection and disconnection. That's not a criticism, this can happen, but it is possible that it occurs again, and we should perhaps avoid it if we can. Yeah? Okay. Excuse me, Mr. Knops, please continue.
No problem, Mr. President. Thank you very much. Mr. President, it's quite telling for the life story of Mr. Ngaïssona and his personality, and also for the appraisal by your chamber of the charges, that his most favorable player in the football team, national football team of Central Africa, was a player of Muslim descent. This person was one of the key players in the national team as of 2010, which team, under the auspices of Mr. Ngaïssona, was a multi-ethnical team. You will hear a defense witness in our defense case, if we would arrive at a defense case at all, telling this court that Mr. Ngaïssona even helped the family of this football player of Muslim descent, in that he arranged flight tickets for him and he arranged travels for him to participate in the national football team of the Central African Republic. You will hear evidence from defense witnesses saying that Mr. Ngaïssona never gave weight to anyone's ethnicity or religion when he dealt with the selection of players within the football team. It is quite relevant for the establishment of the requisite mens rea, as we will submit. This type of evidence, which we'll submit at trial, will show the real personality of Mr. Ngaïssona, his nature as a human being, and will show at trial, at the same time, that this does not fit at all into a theory of someone who resented certain ethnical groups, let alone who had the requisite mens rea to be involved in the crimes charged. On the contrary, your chamber will learn during this trial, through our case, that Mr. Ngaïssona's philosophy was, as one of the defense witnesses will tell your chamber, to make the country smile and give the country some peace through sports, to unify the country. This will also be corroborated by evidence, which is, by the way, also in the hands of the prosecution. And we ask you now to listen to an excerpt as an illustration of the evidence you might receive during our case, which you'll find on number 2 of our list of materials. And Ms. Chiara Giudici will now play this excerpt, which is, by the way, a presentation of Mr. Ngaïssona of April 2014.
Reprendre la fédération en vue de préparer les grandes échéances qui attendent le pays à travers le football, ramener la paix en Centrafrique. Suivez le président Patrice
Mr. Ngaïssona. Something else which I did was contribute to our country to try and bring peace back to the Central African Republic, and also to use football to the ends of peace. Football is an important tool in pacifying the country. Football needs to start again. And we need to see what we can do to get things back up and running. The President of the Republic asked me also to support women's football and to make it into an elite sport. This is something which needs to be done by the Football Federation and with the government and the support of the President. She has asked me to do something, and I will need to do that in cooperation with her. The Central African Republic government needs to not abandon the young people, but rather to use football for their better good, and also to bring back peace, to support peace. The Central Africans want not only to have their country freed, but they also want somebody leading them who can manage them, and I can do that. I'm coming back to football to assist young people and assist the effort to bring about peace.
So, Mr. President, Your Honours, who was actually Mr. Patrice Ngaïssona? How did he live his life in those days of the crimes charged? Defense witnesses close to Mr. Ngaïssona will tell this court that his professional life was on a daily basis dominated by organizing the national team. Their trips to play football around the world. Defense witnesses will tell the court that Mr. Ngaïssona's daily schedule was focused on making this happening, including the finance and the logistical organization of them. Mr. Ngaïssona did not have any assistance to manage all of these activities in those days, to manage the international and national matches of the national team. He did it all by himself, as you will hear from defense witnesses. It was a full-time job, and it was a life philosophy. Mr. President, this does not fit at all into a theory, a narrative of a man who was occupied with or interested in assisting in regaining power in the Central African Republic. When you hear all the evidence, the prosecution evidence and our evidence, this court will conclude that this case is about the distortion of the personality of a man, Mr. Patrice Ngaïssona, as well as his acts. When you have heard all the evidence, you will conclude with the defense that this case pertains to a rush to a conviction, in spite of evidence which clearly points in a different direction. The evidence presented in the course of this trial, Mr. President, will ultimately, as we are convinced, point to just one conclusion. Mr. Ngaïssona did not contribute to the establishment or proliferation of a criminal policy or common purpose resulting in the crimes charged. He was not part of any alleged common purpose plan to reclaim political power in the Central African Republic with whatever criminal intent. The prosecution wants you to believe otherwise, namely that he was instrumental in assisting certain individuals in regaining power through military operations. But this is, as we will show the chamber, a defective theory. The narrative of the prosecution, as we will make clear before this court, does not at all reflect the reality of those days. Several even prosecution witnesses, as we anticipate, will appear before this chamber and will illustrate this defense narrative. So again, Mr. President, Your Honors, who is Mr. Ngaïssona? He had a technical education at the School of Agriculture des Eaux et Forêts, and he earned his title as an engineer in this discipline. In this capacity, he served from 1992 till 2013 on several occasions and positions. Alongside his professional career as an engineer, he had also a long and impressive career in football, as we just mentioned. Nowhere, Mr. President, Your Honors, you will find in his curriculum vitae any reference to a military background. He became the second vice president of the Bangui Football League in 2001 and was elected, not appointed, elected as a member of the FIFA World Club Organizing Committee in 2008, several years before the charges, which is quite a prestigious position. The same year, he was also elected, not appointed, member of the Commission of Young People under 20 years of the Central African Football Confederation. He also became an elected member of the FIFA Member Association Committee in 2017. And in the same year, he was elected as a vice president of the Youth Commission of the CAF. In July 2017, he was again elected president of the Central African Football Federations Union, the UNIFAC, in Kinshasa, Republic of Congo. which includes 8 Central African countries: Cameroon, Gabon, Equatorial Guinea, Chad, DRC, RCA, and Sao Tome et Principe. In February 2008, he was elected as a member of the executive committee of the CAF. Now, why are we telling this today to this chamber? Why are we resuming the history of Mr. Ngaïssona? Why is this relevant for this trial? Mr. President, the mere fact that Mr. Patrice Ngaïssona was so involved and intensely engaged in football, his life was dominated by his football career, but also all these prestigious positions. And we have seen that he assumed quite some responsible functions as elected member of various prestigious commissions within the world of professional football. This all, Mr. President, makes it quite improbable, highly unlikely, that this person had any interest in aiding and abetting crimes or in contributing to a common criminal purpose aiming to regain political power in the Central African Republic, Mr. President. The proper context, therefore, of this trial, and Your Honors, when hearing the evidence, cannot be understood without a genuine portrayal of this person. Mr. Ngaïssona became Minister of Youth, Sports and Culture in February 2013 and held this position only for 45 days as part of the implementation of the Libreville ceasefire agreement, in which a national unity government was created. And this will be supported by the prosecution on evidence, as it's also reflected in the table of agreed facts, which will be discussed during trial. And we simply point for this moment the chamber to document number 5 of our list of material, in which the source cited refers to the implementation of that Libreville ceasefire agreement. So therefore, contrary to the prosecution case, our evidence will show, and as we submit even evidence the prosecution will introduce, will show that Mr. Ngaïssona was not appointed as minister because of an alleged proximity to Mr. Bozizé, nor that he was appointed as minister because he was part of a so-called inner circle or core alliance, in term the prosecution introduced during his opening statement. Mr. President, Your Honors, the history of Mr. Ngaïssona's life, as we will demonstrate in our case, will also convince your chamber that he, Mr. Ngaïssona, was elected president of the Football Federation of Central Africa, contrary to what the prosecution case wants you to believe, not because of any intervention in 2008 by Mr. Bozizé. This is simply to be demonstrated during our case by taking notice of the FIFA rules on election of these type of members, which do not allow any political interference for such a prestigious position within FIFA. To the contrary, our evidence will demonstrate that Mr. Ngaïssona was selected for this position and elected for this position, while one of the sons of Mr. Bozizé's elder brother, Mr. Jean-Roger Ouefio, was the only other candidate, the rival in this election procedure of Mr. Ngaïssona. Therefore, the statement of the prosecution that it was Mr. Bozizé's influence that Mr. Ngaïssona became an elected member of the Football Federation is therefore, in our submission, not correct. Therefore, the selection and election in this position of Mr. Gassona was not because of Mr. François Bozizé, but due to the professionalism and popularity of Mr. Ngaïssona within the circles of FIFA. Otherwise, he would never have been elected, as one defense witness will tell this court in our case. Mr. President, Your Honors, within FIFA, you don't receive a position simply because you have a political ally. It's all about achievements, professional achievements. The world of football governed Mr. Ngaïssona's life, while his endeavors in this regard made his country proud of the national football team. He was instrumental in the growth of football in the CAR, and this was his life story. He renewed the National Cup and focused on the developing of the technical aspects of women's football, as you just heard during the excerpt. The Central African Republic, quite impressively, Mr. President, Your Honors, rose in the ranks of football internationally thanks to the interventions and professionalism of Mr. Ngaïssona, placing the CAR in the first place during the CEMAC Cup, that's the Communauté économique des États d'Afrique centrale Cup, winning the UNIFAC Cup in Cameroon in 2009, and the CEMAC in 2009 in Bangui, all thanks to the endeavors of this man. Under Mr. Ngaïssona's presidency, the national team of the CAR rose from being ranked number 204 out of the 207 countries in the world to the ranking of number 50 in the world, number 8 in Africa, and number 1 in the CEMAC. And this is the reason why people liked him and why he became popular, not because of his political endeavors or any alleged proximity to Mr. Bozizé. And this was the reason why he was eventually approached to become a national coordinator, because of this life story, because of this professional background. If you honors will transpose this life story of Mr. Ngaïssona onto this case, onto this trial, it will create a different narrative as opposed to the prosecution case. So what can we also learn from the history of Mr. Ngaïssona's life? We can all learn from it, Mr. President, that the prosecution case that Mr. Ngaïssona left for Cameroon to prepare or to set up a policy to reinstate Mr. François Bozizé will not withstand judicial scrutiny, as we will submit. After the coup d'etat of the 24th March 2013, Mr. Ngaïssona was forced to leave the country, like many, to end up in Douala in Cameroon. It was the beginning of April 2013, through a transit in Brazzaville. The prosecution case rests upon the assumption that this place was selected by Mr. Ngaïssona because he wanted to stay in touch with Mr. François Bozizé, with the goal or incentive to prepare the response to the Seleka offensive and to coordinate military operations to regain power. That's their case. Yet we will show with evidence the contrary. Mr. Ngaïssona went to Douala in exile because there he could not, forced by the war, continue his work as an engineer, first of all, and secondly, to preserve his important and prestigious work for the Football Federation Central Africa, as we just displayed to the court. of which he remained the president for a second term while even in exile. He had nothing to do with Mr. Francois Bozizé, and during the 7 months of exile in Cameroon, his activities of Mr. Ngaïssona had no relation with assisting or otherwise contributing to the conception of any alleged common plan or purpose, Your Honors. Your Honor, speaking about plans, the evidence will also demonstrate, as we anticipate, that the counter-offensive against the Seleka was not born during Mr. Ngaïssona's stay in Cameroon, nor in Paris. We are convinced that this trial will also demonstrate that there were no reunions inspired or directed by Mr. Ngaïssona to this end. On the contrary, we submit, and we will convinced that Your Honors will, at the end of this trial, accept that the resistance movement to protect against the crimes of the Seleka started initially in small villages of the Central African Republic nearby Chad, and specifically in the Ouam region. And why? Very simple, Mr. President. For many years, the population there was subjected to violence and oppression from Chad. And they were therefore the first ones to resist and to protect themselves against the invasion of those foreign fighters. And nothing to do with an inter-African conflict. It was a conflict which was fueled by foreign fighters, foreign forces. And during this trial, when hearing the evidence, your court will hear evidence and can be conscious that when Ngaïssona returned on the 15th January 2014 in Bangui, he was approached to assume the position of a national coordinator of the Anti-Balaka, exactly because of this life story we just laid out before the chamber, given the fact that the Anti-Balaka groups needed a representative to speak on their behalf in the context of the peace process and to engage with the transitional government. The OTP did not tell you last Tuesday that there are PEXO witnesses, exculpatory witnesses, who explained to the investigators of the prosecution that Mr. Ngaïssona was elected because he was not a fighter and even didn't know the origin of the Anti-Balaka. And some of those witnesses told the investigator, and we will submit that evidence to court, that one of those witnesses will say to this chamber that they wanted someone perceived as neutral and someone who could talk. You find the reference on our list of material number 38 of that witness. That is, Mr. President, Your Honors, how Mr. Ngaïssona became ultimately a defendant in this file. In his role as national coordinator, Mr. Ngaïssona consistently worked towards peace. And this trial, your chamber will hear other evidence and even videos where Mr. Ngaïssona calls for peace following his attendance to the peace talks in Brazzaville. Listening to this type of evidence will convince your chamber, as we submit, that he had no incentive to use violent means to achieve that goal. We will now play briefly an excerpt of such a video, which is document number 111 on our list. It's a video which was displayed on the 3rd August 2014.
At the moment of my return to Bangui, we try to implement our commitments vis-à-vis all the players, vis-à-vis the Central African players who were present during the Brazzaville Forum. As soon as I returned, I tried to recoup the main players of Anti-Balaka and implement the commitments. It's time to restore peace and to put into practice our commitments. We must start peace processes. We in Central Africa, we must also do our duty. We must see the coordinators, and we need to help the people of the Central African Republic. We are lagging behind. It is high time that we do something. Yesterday we had conflicts and clashes. Today we need to find peace. We must go hand in hand in this endeavor to try and save our country. Some want to go to Boali. We don't want any more roadblocks. We don't want these roadblocks. We have to start to hunt down the false anti-Balaka who are carrying out these atrocities. Some even fear their life. We cannot endanger the peace and security of our country. We have to stop this. We must be sincere in our daily efforts.
Your Honours, of course, will have noticed, that's why I mentioned the date, 3 August 2014, that this speech was made after the relevant time frame of the charges. Now, you will ask yourself, why are we quoting from a speech of Mr. Ngaïssona, which was made many months after the charges? It's a very important question. The court will remember that the prosecution's position is that it could reconstruct the relevant mens rea of Mr. Ngaïssona in a retrospective manner in order to establish also alleged prior intent. Now, if the Chamber would follow this reasoning during this trial, it is our submission that it's only consistent and fair if we, in this reconstruction, also pay attention to the actions of Mr. Ngaïssona which contravene the prosecution case. And it's therefore our submission that these type of speeches which we will introduce at trial will indeed countervail the prosecution case. Therefore, this important speech, which was delivered on the 3rd August 2014, which we will present during this trial, will convince the Chamber, as we submit, that there was no mens rea whatsoever which the prosecution has in mind and cannot serve in a retrospective manner to reconstruct and construct prior intent. Mr. President, it's Mr. Ngaïssona's personal life story which will prove that this court, that he is not guilty of the crimes charged. And these are not just words from the defense. The evidence itself will display and demonstrate to this Chamber that Mr. Ngaïssona was a man in favor of peace and against any form of violence. We cite just one prosecution witness who will appear before this Chamber in his statement before the investigators, where he, I summarize, you find it in document 6 on our list of material, where he said that he never participated at any reunion of the coordination of the anti-Balaka, during which any order was given to attack the civil population and the Muslim population. Indeed, these are not just words from the defense. We submit that several witnesses will confirm during this trial this characterization of Mr. Ngaïssona, and already did, some of them, to the investigators of the prosecution, saying that Mr. Ngaïssona even gave small sums of money to people in need in order to prevent the commission of crimes, in order to let them return to their provinces to achieve peace. There were witnesses appearing before this court saying that Ngaïssona was being perceived as someone who saved his country from burning down, using these terms, which will directly contradict the prosecution case, using the metaphor last week, this week, of Mr. Ngaïssona being an arsonist who would not put out their own fire. There was a prosecutor's remark on the 17th February in the real-time transcripts, page 13, lines 9 till 11. Mr. Ngaïssona was even described by one of the prosecution witnesses as a firefighter, to the contrary, who would put out fires. And that's a witness which you will find on our list of materials, document 6. We are convinced that the evidence will tell this chamber that any alleged meeting organized by Mr. Ngaïssona was meant to merely discuss the achievement of peace in his country. As a matter of fact, his continued engagement for peace will be demonstrated by also his public declarations, which we will introduce at trial. As soon as he was appointed as a general coordinator of the anti-Balaka, Mr. Ngaïssona directly expressed his engagement in this regard to work alongside the transitional government in order to ensure the return of peace and security in the Central African Republic. You will see now document number 10 of our list. It's a communiqué de presse of 21st January 2014. And we ask the attention of the chamber to the highlighted parts in this communiqué de presse as an illustration that Mr. Ngaïssona transformed his incentives into concrete actions like this communiqué de presse, which was delivered within the time frame of the charges. Such engagement, Mr. President, on his part can hardly be reconciled with the image of a person who, as the prosecution put it on Wednesday in its opening statement, aside from it, did not get his hands dirty. This trial will introduce various of such public declarations as a general coordinator of the anti-Balaka, in which Mr. Ngaïssona consistently reiterated the movement's engagement into a peace process. On the 1st February 2014, in the time frame of the charges, he declared that the objective of the anti-Balaka, namely the removal of the Seleka coalition, had been achieved, and that this was essential to engage in the normalization of the pacification of the country. It's document number 11 on our list. Again, a display of this communiqué de presse of February 2014. And our last document in this regard is a communiqué de presse of 4 April 2014, where Mr. Ngaïssona requested all anti-Balaka leaders to ask their elements to return to their bases and to ensure the stop of all hostilities. This type of evidence will demonstrate that the prosecution case is also contradictory. On the one hand, it alleges that Mr. Ngaïssona did not do anything in his capacity as a general coordinator. But on the other hand, when he displays actions, it's being said, well, he had apparently the power to monitor and govern those anti-Balaka groups. The prosecution own material, as we will submit during this trial, will tell you a different story. We will now play a video, an audio pedal, of an interview with Mr. Ngaïssona in the time frame of the charges, 24 February 2014, item 97 on our list.
I came back to my country so that we don't have any spokesmen to represent the voice of our children, and everything is going against these children, and that's a pity. There's no spokesman between the anti-Kalama, anti-Balaka and the others in the countries, and the authorities have discussed with these elements. There's also the position which is involved. I discussed with these elements. It's true. We try to work towards peace. These youth have left their countries. They came here on foot and they even had arms, and they want to return. They want, particularly today, they explained to me that these children must do something to wipe this out. We have to do something new, to start afresh, so that the population can go back to their normal activities. They can't go back with arms to their countries. We need security and peace so that we have a chance in the future. That's why I say through these children we can carry out reforms. They've lost their homes, their fields, they've lost everything, but through them we can try and do something, and then do something so that the government is trying to find adequate material so that we can start again. This is the drama we are facing. That's why I'm standing on behalf of these children. Peace doesn't have a price, and we want peace. We have to be able to move freely. They already have arms. They haven't got any spokesman. We aren't seen well, and we have to do something. I must return to my country to help these children. Those who are doing the atrocities, we must stop them. We must fight against this looting. We must fight against this delinquencies.
Mr. President, at the end of this trial, the Chamber will be convinced that the prosecution case reflects in our submission a fundamental misapprehension of his role during the crisis and his position as a peace coordinator. He had no military authority nor background, and like any other peace coordinator, he only heard and observed what happened in his country. We ask the Chamber, when it appraises the role during this trial of Mr. Ngaïssona, and especially at the end of this trial, to keep in mind, Mr. President, that the country in which he was supposed to achieve peace extended over 622,000 square kilometers, with a population in 2014 of 4,854,940 people. 78% of which aged between 0 and 35 years. It defies, as we submit the intelligence of this court, to accept that there be any peace coordinator in the world who would ever be able to prevent or control or redress any crimes in a country of such a size. And before we further unfold our defense case, Mr. President, the Chamber should also be aware, when listening to the evidence of the prosecution, that its case reflects merely a selection of witnesses, with only the purpose, of course, from the perspective of the prosecution, to arrive at a conviction. Your Honours, at the end of this trial, you will have heard numerous witnesses which will be presented by the Office of the Prosecution. But you should ask yourselves at the end of that trial, will these witnesses have given you a complete picture of the reality in those days? Our answer will be no. This trial, at least the prosecution case, will show that various witnesses were not called by the prosecution and do not fit into its case theory. We will present to you witnesses who were on the ground. They will tell you the real narrative. The narrative about not only the history of the case, but also the real narrative about who Mr. Ngaïssona is and what he actually did during the conflict. Mr. President, the court should also be aware, when hearing the evidence during this trial, that a total of 64 in-crim witnesses who also gave partially exculpatory statements to the investigators of the prosecution, who were initially on the list, have since been withdrawn after the confirmation of charges. Now, it's of course the discretion of the prosecution, and it's laudable that they try to diminish their witness list. But at the same time, the Chamber should be mindful and should keep in mind that its list, therefore, as we submit, will not provide a full picture of the case. And it's the case of the prosecution, which we'll present to you, which reflects, therefore, a narrative which was told to the prosecution witnesses, to the prosecution investigators, and which, therefore, will not reflect the entirety of the reality on the ground in those days. You will not hear during the prosecution case witnesses who described Mr. Ngaïssona to the investigators of the office of the prosecution as a person whose activities during and after the crisis were only concentrated on reconciliation. One witness was even telling the investigators that the little money Mr. Ngaïssona had to uphold his family was even used for him to give them to people to have them return to the region and to assist them in their daily lives. Document number 20 on our list of materials. You will not hear, during the OTP case, a witness who told the investigators of the prosecution that Mr. Ngaïssona, with his very limited financial means, did everything what he could do within his abilities to achieve peace. Document number 21 of our list of materials. Are various examples, and for the translation booth, I will now skip several examples in my submissions, and I will go to paragraph 37 of my presentation. Another prosecution witness told the office of the prosecution, you will not hear that during the prosecution case, provided an account of the planning and unfolding of the 5 December attack, which directly will contradict the prosecution case about Mr. Ngaïssona's alleged contribution to this attack, as is, by the way, confirmed by the pretrial chamber in paragraph 101. That witness described to the investigators in detail how the ex-FACA organized alongside the anti-Balaka descended upon Bangui without exterior assistance or guidance, except for the assistance of the French Sangari forces. You will not hear this witness in the prosecution case what he told the investigators, that apart from the Sangaris, that attack was not discussed with anyone and not coordinated by or with anyone else. Document 29 on a list of materials. That witness, which you will not hear, told the investigators that following the overthrow of Mr. François Bozizé, many fled to Cameroon. Mr. Ngaïssona was amongst those many, with others. And this will also confirm, and we are convinced that we are able as defense to convince the chamber in this regard, that indeed Mr. Ngaïssona didn't go to Cameroon to align with Mr. François Bozizé. He took a route that thousands of refugees from the Central African Republic took as well. And this witness, which you will not hear during this trial in the prosecution case, but which you might hear during our case, told that Mr. Ngaïssona only came into the picture afterwards, after the 5 December attacks, and was not involved in those attacks. The same witness saying that he did not have any military power, did not give any military orders, because he was a simple civilian. document 30 on our list. A witness saying that Mr. Ngaïssona was a man of peaceful actions, that he was like, his house was like an orphanage or church, telling the investigators that every morning the population of Boy-Rabé would gather in front of his house and Mr. Ngaïssona would help them with medicine or would give them a bit of money to help. Mr. President, the Chamber can conclude from these remarks of the defense that when you will hear the prosecution case, you should be mindful that its case is indeed based on a selection of witnesses which are meant to fit into a narrative which is there to support a conviction. And this approach in the prosecution case, as we will demonstrate, is not limited to simple witness statements. We give you another example. The prosecution has alluded to a speech which was allegedly made by Mr. Ngaïssona 8 months before the time frame of the charges. Prosecution submits that this speech of Mr. Ngaïssona was a call for support against enemies of the nation who decided to bring trouble by bringing Sharia law and who wanted to use Islamism to destroy the country. A call, therefore, to galvanize the youth against the so-called foreign invaders and to organize a march against the crimes blamed on them in an appeal to the Christians. But the prosecution, as we will submit, will present this speech merely on the basis of a selection and tries to turn this call into a call to galvanize the youth. But we will prove at this trial that this assumption is not correct. This speech was not made at the eve of the coup on 8 March. The speech was made on 4 January 2013, at the eve of the Libreville peace talks, in order to place the peace discussions in the hands of God. Document 4 of our list of materials. Moreover, we will submit at trial that this call, placed in its proper context, was not a call to create a rebellion against Muslims, but a call for peace, for dialogue, for joining Muslims in their prayers. It's clearly stated, if your honors will see the speech at trial, and I'll just quote briefly in French, Nous allons supplier Dieu de bénir l'année 2013.
Let us pray that God blesses 2013 to preserve and keep peace, which He has given us finally, so that our citizens can live in peacefulness.
Therefore, the speaker recalls that God answers the prayers of the Muslims and the Christians and pacified the crisis. This march was intended to include Muslims, not exclude, not only through a call to join their prayers, but also to join the march. School principals and of several establishments, including a Muslim private school, were even invited to this meeting to organize this march. Rather, therefore, than exploiting division, as is the prosecution case, this speech actually called for unity and peace and fits into the narrative of Mr. Ngaïssona's life and personality. We will ask your chamber in conclusion, Mr. President, to keep this example in mind when you will hear the evidence during this trial. When we speak about the prosecution drive for a rush to conviction, we will show you that the evidence presented during the prosecution case and during our case will not withstand the highest evidentiary standards which this trial requires. It's striking, therefore, that the prosecution will ask you to pay attention to what they call contemporaneous Facebook communications by, mind you, third parties, not even attributed to Mr. Ngaïssona as being the alleged author. and in doing so to ask your chamber to prove key elements of a criminal case theory, such as, in his case, the element of alleged orders, the element of alleged provision of equipment and ammunition. Now, Mr. President Jonas, we asked the chamber that the issue of admissibility of social media evidence, which we will argue at trial, of course, has already led to relevant jurisprudence in the United States of America, indicating that Facebook messengers become a main concern and has impacted upon the judicial findings of several courts. Just one example. The US Federal Court of Appeals Second Circuit ruled in 2014 in a very important case, United States versus Vayner, that the mere fact that the page with defendant's name and photograph happened to exist on the internet at the time of the investigator's testimony in that case, according to the federal court, does not permit a reasonable conclusion that this page was created by the defendant or on his behalf. And mind you, this was even a page where the name of the defendant as the alleged author was mentioned. And therefore, Mr. President, Your Honors, when you will hear potential Facebook evidence at this trial, we ask you to be aware of the conclusion of also experts such as Dr. Rebecca Hamilton of the American University of Washington, D.C., in a very important paper, which you also, speaking about the context of mobile instant messaging evidence, so-called MIM evidence, says that the technology nowadays enables, with the minimum technical skills, to create forgeries that are undetectable to the lay eye. Publication of 2018. The Chamber, as we submit, will learn during this trial that Facebook evidence is, as we will prove, not reliable at its face. It's not self-authenticating, partly due to the anonymity resulting in the use of pseudonyms as usernames. Other risks we will submit during this trial will appear and were already identified by also the Court of Appeals of Texas in the Tienda versus State case, 2012, an important case when it concerns the veracity of Facebook messengers and the value of those messengers as criminal evidence. And also that court ruled that that type of evidence without more is not sufficient to support a finding of authenticity. Mr. President, Your Honors, it is our submission that this chamber should keep these reasonings in mind, these rulings in mind, when the prosecution will ask you to look at Facebook evidence, whether messenger or posts, such as evidence the prosecution has already quoted and displayed in its opening statement on Tuesday. With regard to Facebook messengers and posts emanating from unknown individuals, such as from the account, quote, Coordination des Anti-Balaka, Coordination des Anti-Balaka, the chamber should also keep in mind what the pre-trial chamber in this case already held in paragraph 202, where the judges ruled that Facebook entries must be assigned limited weight in the absence of evidence led as to the identity of the person using the account entitled Coordination des Anti-Balaka. Your Honors, we ask you to keep in mind when the prosecution will introduce this type of material, what was held by this pretrial chamber number 2 in paragraph 202 in this regard. And we will ask you, in our case, to ignore this type of material because certainly when Facebook comments are made by an anonymous Facebook user to a post made on an anonymous Facebook group, in other words, from unidentified sources, unknown even to the Office of the Prosecution to not pay attention to these type of materials. And lastly, it is our submission that comments expressing anti-Muslim animus made in private by individuals other than Mr. Ngaïssona, as displayed by the prosecution last Tuesday in their opening statement, can not be accepted, that cannot constitute evidence before this court that he himself, Mr. Ngaïssona, shared such anti-Muslim animus or sentiment. The prosecution's attribution in its case of such quotes and speeches made by other individuals than Mr. Ngaïssona, simply by virtue of those individuals and Mr. Ngaïssona allegedly being part of an inner circle, should not be accepted by the court, as we will submit. Such an approach stands, by the way, in stark contrast with the prosecution's own submission last Tuesday in the opening, saying that this trial is, we quote from the real-time transcript, is singularly about whether Mr. Ngaïssona bears criminal responsibility for his own actions. Singularly. Therefore, what other people might have said about Muslims is not something which we can attribute to Mr. Ngaïssona himself. Mr. President, in the remaining part of our opening statement to forecast our defense case, I will now briefly go into the origin of the conflict and the relevance for our defense case. And secondly, we will delve into and we will unfold our case as to the proper role of Mr. Ngaïssona during this conflict, especially in regards to the allegation that he was part of an inner circle or so-called core alliance. I will try to finish before the break the second part, the origin of the conflict and the portrayal of the anti-Balaka in this conflict and the relevance for the defense case of Mr. Ngaïssona. The case against Patrice Ngaïssona, Mr. President, and the appraisal of his role as national coordinator cannot, as we already alluded to this morning, examined in isolation of the social, political history of the Central African Republic and its military political context in 2013-2014. When your honors will learn during this trial from this context, either through experts or witnesses, you will understand why Mr. Patrice Ngaïssona cannot be found guilty of the crimes charged. Last Tuesday, the prosecution in its opening statement started its presentation with the following words, I quote, Mr. Ngaïssona was a member of Bozizé's inner circle. He helped put together a fighting force composed, amongst others, of Bozizé's former presidential guard, members of the Force Armée Centrale Afrique, which I will refer to, words of the prosecution, as the FACA, pre-existing self-defense groups, new recruits, and others to forcibly remove the incumbent Seleka regime. Now, we are convinced that this trial will not establish these allegations of the prosecution. It is our case that the anti-Balaka groups were, first of all, spontaneously created, which as such is not disputed by the prosecution, I learned. Second, that they were without any central control. And third, there was no political force or entity or drive behind them. It was a self-defense phenomenon. As to the spontaneity of the anti-Balaka, we will show during our case that the origin of that conflict had nothing to do with the creation of a criminal policy resulting in the commission of crimes against civilians on the assumption of regaining power, nor a plan which allegedly found its origin in ethnic or religious affiliation. Rather, as we will establish during this trial, the various anti-Balaka groups emerged simply on the basis of the need to protect. Protection of the lives of the population in the absence of a proper law enforcement system. There was no police, no army anymore present to protect the population. That was the real origin of the emergence of all these various not organized groups of the so-called anti-Balaka. And while we unravel this history, which started, as we just submitted, in the Ouam region nearby Chad, and gradually spread out through the country, while we unravel this political social context, it will be shown to the chamber that Mr. Ngaïssona played no role whatsoever in aiding, abetting, or otherwise assisting those groups in the commission of any crime. The truth, Mr. President John, the truth is, as we will submit, is that many of those self-organized self-defense groups spontaneously arose to respond to the violent Seleka advance in the country, in the absence of a law enforcement system. And at the time of the conflict, and when this ensued, all of these groups were totally unrelated to Mr. Ngaïssona or the KNK, which was the party of Mr. Bozizé. Their formation was therefore completely spontaneous and did not emerge at the behest of any person. Now, Mr. President, will this trial present evidence to this? Yes. We are convinced that this will be established at trial, because even a prosecution witness told the investigators, and that's document 35 on our list, and he will appear before this court, telling the investigator that the anti-Balaka movement began as a response to the brutality of the anti-Balaka, of the Seleka forces, With respect to the 4th arrondissement in Bangui, that witness told the investigators that the security forces were fleeing and that the people felt they had to rise. They had to rise up in the absence of any protection. This trial will establish, Mr. President, what also this witness told the investigators of the Office of the Prosecution, that the raison d'être of these groups was simply to defend their country, pour défendre leur patrie, les Centrafricains. Ils sont organisés en autodéfense.
They organize themselves in self-defense
pour défendre notre patrie.
To defend our fatherland.
These are the words of a witness who spoke to the investigators of the prosecution. And he also told them that there was no chef, there was no boss. Ils m'ont dit, ils n'ont pas de chef.
And they said that they didn't have a leader.
We will submit to this trial, Mr. President, that the anti-Balaka was rather a resistant movement. It was not based on an inter-African conflict, but a conflict which ensued from the outside, the exterior of Central Africa. An invasion by foreign fighters which comprised 80–90% of the Seleka. Reports which are presented by the prosecution. Document number 9 on our list, you also find another prosecution witness which will appear before this court and told the investigators, I quote, face à toutes ces atrocités,
faced with these atrocities and crimes that the Central African people were suffering, the young people of our country, coming from the provinces, joined together in resistance, as the French did against the Nazis back in the day, against the Nazis.
So this witness of the prosecutions is making the comparison with World War II, when France was invaded by a foreign force, Germany. And that's why this organization, this anti-Balaka movement, came across. Secondly, no coordination. We are convinced at this trial that these groups were far from organized, Mr. President. And we will come back to this topic later during the presentation, making any coordination amongst them virtually impossible. It's quite telling to this chamber that one witness whom the prosecution investigator spoke and will appear before this court told them that we got the impression that there were different anti-Balaka groups in many areas and elsewhere, but there was no coordination amongst them. These were the words of a witness speaking to the investigators of the prosecution. We ask your honors during this trial to keep all these words in mind. No coordination, especially when you, chamber, will assess the role of Mr. Ngaïssona. Now, the last element, was there any political or religious motive behind the movement of the anti-Balaka? The answer during this trial to be established is no. Prosecution witnesses, as we anticipate, will appear before this court saying indeed there was no political or party or politician behind the creation and the actions of the anti-Balaka groups. You'll find an example, document 104, on our list of material, where that witness told the investigators, I quote, there is no political party or politician behind the anti-Balaka. I can tell you that I know that you are here to investigate what happened in the car and to find out if we were pushed to do this by a politician or political party. We were not. This witness tells the investigators of the prosecution they were not pushed by anyone, no politician, no political party, no political motive to engage in this self-defense. So, Mr. President, there was no use of any pre-existing groups by anyone, let alone any politician, as suggested by the Office of the Prosecution. In fact, during this trial, it will become evident, to your honors, that the prosecution ignores the results of its own investigation. Its own investigation show, as we will submit, that the anti-Balaka movement was unstructured. It was impossible to subsume this movement under a central control, such as, for instance, somebody like Mr. François Bozizé or Mr. Patrice Ngaïssona or any other member of any alleged inner circle. In making the argument that the anti-Balaka groups became a structurized organization, the argument of the prosecution, with the help of Mr. Ngaïssona, their theory, the prosecution, as we will submit, presents to their chamber not the reality on the ground. The reality on the ground was not that there were just two groups that arose in response to the Seleka attacks in the lead up to the crisis, namely Kokora and Kowak. No, the evidence will show there was a multitude of resistance movements, a multitude of groups constituting this popular resistance movement, created by the citizens, the population itself, without any central control or drive. It was all totally unrelated to Mr. Patrice Ngaïssona or any other politician in those days. Many anti-Balaka members, as we will show the chamber, did not even want to affiliate with any politician. And Mr. Ngaïssona was later simply chosen as national coordinator not because of his political affiliation, but because of his neutrality, his popularity, his achievements in football. This social political reality, Mr. President, which we will submit at trial, will disprove also, and this opening statement is not about a legal argument, we realize, but will disprove that the anti-Balaka cannot constitute an organization in terms of the Rome Statute. We can say it not more clearly than a report of the International Crisis Group of 21st September 2015, which is part of the prosecution material and in our list of material, document number 34. And I quote in French from this report to conclude this part of my submissions. Derrière
There was a plethora of groups of different types, with different geographical origins and political affiliations that were more or less effective behind the term anti-Balaka. End of quote.
This is our defense case, showing this chamber that the combination of the spontaneousness of this movement, the absence of a political drive of party behind them, the absence of any coordination, makes the prosecution case highly improbable and make the chamber convinced that the prosecution case cannot be proven beyond any reasonable doubt. Your Honours, this trial will also answer another important question which the prosecution did not address in detail in its opening statement. The question is, why were these self-defense groups created and what was their motive? Is this question important? Yes, because it will contextualize the actions of Mr. Ngaïssona and specifically the speeches, because in the prosecution case, the speeches are apparently a tool for the prosecution case to show that Mr. Ngaïssona used rhetoric to galvanize the population in the regaining of power. We believe this trial will give you another answer to this important question as to why these self-defense groups were created. Evidence will be presented before this court which will show that foreign fighters were essential in the bolstering of the Seleka forces. I mentioned this already before. It was not an inter-African, Central African conflict. It started with a foreign invasion. This specific contextual element, Mr. President, Your Honours, makes it quite clear why this resistance movement spontaneously arose. This phenomenon of foreign fighters will therefore disprove, as we submit the prosecution case, that the conflict was ethnically or religiously related. It was not. The court will learn from, amongst others, a report from the Fédération Internationale des Droits de l'Homme, which is part of the prosecution documents, and we will submit this during our case, that 80% of the Seleka forces may have been made up of Chadian or Sudanese fighters. Document 39 of our list of materials. Document 40 on our list contains the written testimony of the Bishop of the Diocese of Bossangoa, submitted to the House Subcommittee of Africa, Global Health, Human Rights and International Organizations, which tells the court that as much as 90% of the Seleka fighters were made of Chadians and Sudanese fighters. Moreover, prosecution witnesses, as we will expect, will appear before the court to corroborate this evidence, in that they will confirm that the Seleka forces were able to strengthen their ranks through use of mercenaries. You will be made aware during this trial that one prosecution witness told the investigators of the prosecution that he saw Chadian military vehicles during patrols in Bangui. And he will affirm that some vehicles belonged to the official Chadian forces and others were from paramilitary groups in Chad, document 42 of our list. Your Honours will observe at this trial what the implications are of this military political element. It will disprove the allegation that the incentive of Mr. Ngaïssona to address the population in the car with certain speeches was done with so-called rhetoric. The statement allegedly made by Mr. Ngaïssona in January 2013 on his behalf about foreign invaders, which is also referred to in paragraph 61 of the prosecution pretrial brief, was exactly made to denounce this phenomenon, not to galvanize the population. There were indeed people from outside the car within the ranks of the Seleka when they attacked the car population. The prosecution wants you to believe, Mr. President, during this trial that such references by Mr. Ngaïssona were merely made based on rhetoric and that he was equating foreign fighters with Muslims of Central African descent. We will make clear during this trial that this prosecution assumption that Mr. Ngaïssona alleged references to foreigners were not a thinly veiled reference to Muslims, but was simply to alert the people to this invasion, to this danger. We'll submit during this trial that the crucial role of mercenaries will countervail the assumption that Mr. Ngaïssona was engaged in anti-Muslim rhetoric before Mr. Djodja's rise to power. To the contrary, we'll submit that it was the phenomenon of foreign fighters within the ranks of the Seleka which created grave concern within the population. As one prosecution witness told the investigators, I quote, "Moi, j'ai vu plusieurs véhicules."
I myself saw several military vehicles from Chad. Several. If it wasn't 100, if it wasn't 200, several. And that was throughout the city of Bangui.
Mr. President, it will be important for the court, and I go for the translation to paragraph 69 of my submission. Paragraph 69. It will be important for the chamber to be aware when you hear this evidence that another prosecution witness told the investigators that the Seleka were indeed mercenaries and did not follow the rules of war and combat. They targeted not only Christians, but also the population in general. Document 44 on our list and document 45 on our list refers to a witness telling the office of the prosecution in similar words about this phenomenon. At the end of this trial, Mr. President, Your Honors, you will be convinced that it were the Seleka attacks which was at the heart of this resistance movement, meant to defend the population against the invasion of foreign fighters, which were meant to facilitate the operations of the Seleka units. That was the political reality of those days. The anti-Balaka move was therefore not about attacking civilians because of religious or ethnical affiliation. It was about defending their lives. And why would that be the case when so many of the prosecution witnesses, as we submit, told the investigators that Christians and Muslims lived in harmony before the whole crisis started? Mr. President, during the conflict, the interference of foreign fighters was not limited to neighboring countries such as Chad and Sudan. The Chamber will, as we submit, hear witnesses explaining how a crisis depicted by the media and the prosecution as being a clash between two religious communities, an inter-African fight, arose simply based on economic motivations of foreign powers. It's now quite cynical, Mr. President, to notice that Mr. Ngaïssona, the man in this courtroom who is held responsible for the crimes committed during this crisis, is in fact the man who tried to put out the blaze created by foreign powers and economic powers. This man is now before you, Patrice Ngaïssona. It is important to be aware, Mr. President, during this trial, that those same foreign powers, after having seen the humanitarian disaster created by the arrival of Seleka, which was supported by Western powers, ultimately decided to switch positions and started to support the anti-Balaka. So when those Western powers did observe this huge disaster created by the Seleka, they realized their mistake, that they gambled wrongly in economical sense. Several witnesses explained this already to the investigators of the Office of the Prosecution about the involvement of the French Sangaris operation, the famous operation, in the organization of the 5 December attacks, where they were involved. 1 month after this attack, Mr. President, Mr. Jotodia resigned under the pressure of the international community. This was exactly what happened. And it's indeed cynical that now Mr. Ngaïssona, in view of the prosecution, has paid a price for this disaster, which was created by foreign powers. Mr. President, any political leader or peace coordinator would have criticized such foreign intervention. In his country, any political leader would have done so. Therefore, Mr. Ngaïssona's alleged calls and actions had nothing to do with ethnic or religious bias. It had nothing to do with any anti-Muslim rhetoric in this regard. If the chamber positions this conflict in its proper military, social, cultural context, it can only arrive at the following 4 conclusions, and that's where I end my presentation before the break. First, the anti-Balaka arose spontaneously in response to the Seleka crimes and thus consist of several disorganized groups that one could not subsume under one person or political leader. 2, the anti-Balaka cannot constitute an organization within the Rome Statute. 3, the Seleka coalition was indeed largely composed by foreign fighters from other countries, which reflects on the mens rea of Mr. Ngaïssona and the interpretation of his speeches. And 4th, those public speeches alerting to this reality by Mr. Ngaïssona did not amount to mere rhetoric aiming at fomenting division along religious or ethical lines. Mr. President, thank you. I see now at the clock that I'm 2 minutes after the time of the break. After the break, I will conclude my submission with the 3rd part, after which Mr. Omicine may well take the floor. Thank you.
Thank you. We will have half an hour of coffee break.
All rise.